I'm Kurt Arbuckle. I'm a Houston attorney, and I'm a litigator. That means I try lawsuits for clients. And one kind of client I often have is one who's been injured due to the carelessness or negligence of another person. A question I often get asked in those kinds of cases is, what if the other side was mostly at fault, but I was partly at fault? And the answer is that Texas has what's called comparative fault. If you are found to be more than 50% at fault for whatever happened, you get nothing. But if your percentage of negligence is less than 50%, then you get whatever percent is not attributable to you. So the court will take all the parties who might be responsible and will ask the jury to assign a percentage to each one. If your percentage is 49%, you'll get 51% of whatever the jury decides should be your damages. If your fault was 5%, then you get 95% of whatever the jury decides. But ultimately, the jury will decide what the percentages are that are assigned to each person. So you still may be able to recover for your injuries due to the other person's fault, subtracting out any fault that may be your own. Fortunately, most cases, 80 to 90%, settle long before the jury gets to that point, because they settle before a case is even filed in court for trial. It's settled in negotiations, and I've talked about that in other videos that you may want to look at. So don't be discouraged if you are 5 or 10% at fault and the other person or group of people or group of companies was more at fault. You still have the right in Texas to recover your legitimate damages.